is the Lao Tzu case about a crucifix in Italy.
Okay.
And part of the reasoning, either subterranean or exposed, was that if you were in another country, or if you tried now to put a crucifix around the classroom, it would be clearly illegal. But the fact that it's been there forever brings a component of cultural heritage that, although it's then substantiated through something that would be illegal right here, right now, or in the future, is okay. And I don't know if the reasoning is the same, or maybe it's the same in both cases, but it's subterranean. But there's something to it.
No, I would agree. This is surely one of the interpretations. You know, that it's already there. It's a part of our cultural heritage, and it should be there just to as a sign that those things should not be repeated in the future. I agree with you.
Okay, I have a comment about the origin of human dignity. I would not agree that it comes from equality from all the people, and that it's like an ambiguous and indefinite term. From a natural law point of view, it has an absolute nature because it derives from absolute source. That is, human is created by image and likeness of God. Thus, it has absolute and unalienable character, and not at all relative.
It's a good point, but I would say this is only one interpretation of the origins of human dignity, a religious interpretation which is connected with the notion of supernatural, you know, that God created all the people and gave them a human dignity and equality.
But if I may,
yeah.
I have exactly the same point. But what he's insisting on, and what I think is right. I mean, you are constantly saying that the concept of human dignity is ambiguous. It doesn't have a proper content, and all these, the self-fulfillment that follows from it, and the equality, which is a consequence of human dignity. This just proves that purely on secular grounds, you cannot define human dignity. Because we have to admit to ourselves that we are part of the 2,000 and more years of Judeo-Christian tradition, from which, in these places, in these countries, in these territories, the concept of human dignity has been derived, right? And it's just like that, and it's very difficult. Like Carl Schmitt, for example, he said, and this provocative, of course, that all legal concepts that we deal with are actually secularized Christian concepts. And having the human dignity as such, it's very difficult to define it merely on a secular basis or secular premises, because your definitions will be constantly tautological. You say, oh, so we have human dignity because we are humans. So, but why the animals? Why don't they have their own dignity, which would be comparable to humans, right? But then you say because they're animals. But how do we know that they're animals and that they're not humans? So it's very sometimes. Sometimes we just can't explain all things with a reference to what is here and now. There are many things which are beyond us, right?
But we can use our contrary.
And we take, sorry?
We can use our contrary.
That's the fifth one. But, as in the as a preamble to the American Constitution, they say, we believe we are all created equal. Right? We take some things for granted.
No, but it's a good point. I don't disagree with this point, and I also didn't try to put forward that the notion of humanity is a secular concept. I would just say that a different dimension of human dignity, and Christian tradition is one of them. And there are, I would say the human dignity is more a pluralistic concept. Depending on the tradition you come from.
I would say, either in the because we are all created in God's own image, or in its secular equivalent, right? Whatever it is.
Sure. I add just one legalistic point, which goes back to those arguments that were taken into position before. I I would agree with you that according to the argument of principle, so also all other names should have been eradicated. But isn't there also an argument of policy that courts take into consideration? And so it was balanced to some degree. And it would be outrageous for at least for 1/2 of the population for various reasons.
No, you're right. I mean, the reason why the court decided in such a way, in such a manner, is it's a policy. You know, it had to draw like a middle way between the two different contrary conceptions of human dignity.
And that's also part of law.
I agree. I think it was strategically decided
Yeah.
it will be taken by consensus, like Brown versus Board of Education.
Yeah.
Right? Because when society is so split, when certain issues are so controversial, and so that the court has to interfere, the court will only achieve certain outcomes if it basically decides unanimously. And here, if you read the judgment, and it's available in English, you will see that these judges basically, the judgment is about agreeing to disagree. I argue it's an incompletely theorized agreement between judges. So there is unanimity, but the way they arrived to the conclusion, they're completely incompatible paths that to the same result.
Sure. Just a short comment on your exchange, because if I got it correctly, Filippo's argument was we can tolerate those past things because, well, they are part of our cultural heritage. So we can tolerate. Right?
Well, they might have said, and I reported.
And your argument was, yes, we can. Some people think that we can leave those monuments. Not because we tolerate it, but because they are a sign of what happened and it was a bad thing, and so it reminds us of bad things. But the argument is different. I mean, and it's a strange argument. That one is a strange argument because the default reading of a monument is it's an important thing, it's a good thing. So if I think of a monument of Mussolini in Italy, I mean, it's strange to think that you leave some monument honoring Mussolini in order to remind people that he was a bad guy.
Maybe I would just add something to John's statement on
And maybe you should move to the table. Now it's a good opportunity to do so.
safer in the background. Nobody notices you, you know? I've noticed, for example, in Trieste district court, you have it's a huge palace, and then on top of it, there may be 4 fascial signs, which are typical symbol of the fascist period, and nobody really care about it. So maybe I would agree with what the speaker or the leader said that they're basically part of our past. Not necessarily something bad has happened. There's just historic. They have a historic value. Maybe. You have in your own country some experiences with this as well.
But these symbols are not of fascist origin. This comes from Rome. You can see this, like you can see this in the United States all over.
Like the red
The
star.
swastika comes from Mexico.
Like the red star, you could argue that is not or it is a sign of communism.
Yes, I can see these totalitarian regimes try to efface everything which was before them. For example, I was in Ljubljana and all in one place which is called Slovanska Knjižnica. There are some monuments from old Yugoslavia. So nothing was left. The same, I think, was in Germany or perhaps even in Italy. At least in Germany, they also tried to eradicate all Jewish culture and things, which was a big heritage.
Right.
I just want to add a short commentary. It's like a mediated solution that they found in Hungary, for example, and in Lithuania. It was like to remove those monuments from public places, but they put the monuments in a special park. So in order to, so there is, well, it was a way to reconcile both nostalgic and and people who want to
Make money.
They are free of charge.
That's a good point. I mean, history belongs to museums, right? That part of history that we are not proud of. Otherwise, we are sending very strange messages to the future generations. And the problem in Slovenia is it is so deeply seated that here there is just in one part of the society and in a very important part of the political elite, and in those powerful parts of society, there is just no awareness that totalitarian, what we actually have, we have to say, have lived through, because we're still living through it somehow, that this, there's no awareness that this actually was a totalitarian regime. So there's no consensus as to whether the communism that we had for 50 years was totalitarian or not. So, and for some, this decision of the Constitutional Court would be completely unacceptable because it derives from a premise which is unacceptable, and that is that the previous regime was totalitarian. Because you will still have great parts of the population, especially the elite, who would argue that the communist system was a system that liberated Slovenes and was an emancipatory system that freed us from, I don't know, from the shackles in which we were thrown by all other nations surrounding us, etc., etc. So it's, I mean, the problematic thing is that deep down, the very premise from which we should be, on which we should be standing and building everything upon it is deeply contested, right? And this is just, I think, a very uncivilizational moment in Slovenian political sphere. Just certain basic, fundamental civilizing impulses are just missing.
I would argue that also in National Socialist Germany, most of the Germans wouldn't agree that this regime is totalitarian. They had to be convinced otherwise with arms. So we have to use force sometimes.
Okay.
In this such
On this note,
version, okay, force maybe is not
If you're
legal force.
But one thing is for sure, you cannot tolerate fundamental violations of human dignity.
This is a minimum core of human dignity.
All right, so I won't use any force, but I have to close down this Jerne's talk, Jerne's presentation. To, I think it's Filippo, who's already there.
yes.
And he's going
There was a
to
reason.
speak of the emergence of judicial tests as an efficient source of international law.
Thank you very much. Let me just get the PowerPoint ready here. So first of all, sorry, I did two things at a time. Is that mine? Can't see. Yeah. So thank you very much. Thank you very much to Marco, Jerne, and Matej for inviting me and for adopting this affirmative action strategy whereby outliers like me would have a place in a shrine of legal theory like this. I have no idea what this is. Yeah, can someone find presentation?
Via projekcja is it?
F5.
Yes.
Oh, okay, got it.
We can do
Okay,
it.
first one.
Yeah. Good. So, because I'm not an expert in legal theory or jurisprudence like you are, and therefore I would like to have your input on this. And it's not the usual boilerplate disclaimer, work in progress, I would like your comments. I really need your comment, because I'm sure there might be something original there, but there's also a lot of stuff that for you is banal, and you might just help me giving me the right direction here. So what I will be talking today is judicial tests in international litigation and what they are and why I think the rule is slightly equivocal in the system of sources of international law. This is the outline. If I find, oh wait, I got two. This is the outline more or less. I will try to give you a definition of what I mean by judicial test, but that is not the fundamental part. Just trust me, suspend your disbelief. I'm sure there will be better definitions, but I'm not interested in defining it. Just bear with me until we come to the point where we discuss it, and maybe at that point you'll be able to point at flaws in the definition, but also at something that's more inherent to the discussion. And we try to figure out what they are for, give you example, because I know you're into pure theory, but the spirit is willing and the flesh is weak, so we all like examples. There will be examples. And, and then I will try to investigate the role of judicial tests, the way they work right now, give you excerpts and examples from the case law. So the purpose of this presentation, I give you the jurisprudence and you give me the jurisprudence of it. And then, in the end, I will try to see whether or not it would be better or appropriate to find a place for judicial tests in the system of sources of law. Now, an example that you might know about already, just to be on the same page in terms of what is a judicial test. A judicial test is obviously something that is formulated by judges or by judicial bodies, and it's not something that you find in a provision, but usually has the purpose of putting into operative terms some norm. In this case, the norm would be a norm of customary law that would say more or less something, it's unwritten, so we don't know what it would say, but it says something like states would be responsible in international law for acts committed by non-state private individuals in light of a strict connection between the subject and the state. So there is this rule of straight attributability of of action, and this is an example. And then we have cases where the ICJ, the International Court of Justice, try to create a judicial test to decide when it is possible to attribute to a state the responsibility for acts committed by individuals. And the test is famous of effective control, and so the court says that we have to look at a relationship of dependence and control between the state and the individuals, and that is the only way we can actually attribute the responsibility for these facts to the state. It's been used in the Nicaragua case in '86, it's been used recently in the genocide case in 2007, and it was so influential that if you now look at the articles on state responsibility that have been finalized in 2001, it just reflects the wording of the judicial test. So it emerged in the case law, and then it became the codified version of customary law. So this is a test, and just keep this in mind, because now we're going to talk about other tests and what they are for. Right, so I would say there are at least, I'm not saying this is just two functions, but at least two main functions of judicial tests. One is to operationalize some principle of law under the assumption that the principle itself gives an indication of direction, but it doesn't give the rule that has to be applied in a specific case. Taking the principle, one has to extract the rule for the specific case, and the test helps the judge to do this in a consistent way. The other function that is pretty common is that of defining a non-legal element of the norm, or an element that is not just legal but has a factual element to it. So if you're familiar with EU acts, you know that as a matter of best practices, there's an initial part of every EU legal act that comes with a glossary, with a definition of all the elements that are used in the act and that are not completely and already settled legal definitions. So they say abuse of market power is blah blah blah, and we mean by situation of minority this and this. And this would be something that, if it's not done by the legislator, judges usually do through judicial tests. And mind you, the two functions are not, probably they're not the two only ones, and sometimes they merge and sometimes they overlap, of course. but they are there and they are discernible. What's so equivocal about this test? So why am I interested in questioning the nature and the status? Let's remind ourselves that in international law, at least in principle and at least formally, there is no rule of stare decisis, or as they call it, stare decisis. And therefore, it's not obvious, it shouldn't be granted that precedents have some bearing on following case law. The continuous use of judicial tests, lock, stock and barrel, you find the same paragraph over and over. Once it's formulated, you can find the same test used as is over and over. It's something that is not implied in the structure of the legal system. So we have to find a way to justify it, possibly to challenge it. Right, so we have another case. The state attribution of effective control was more a case of operationalizing a principle, the principle of state responsibility, whereas this is a case where the judicial test tries to give a definition of a non-legal element. So in investment arbitration, there is a threshold question. Are we dealing with an investment in this particular case? Is this guy coming in with some sort of interest, but is this an investment? So an arbitral tribunal tried to create a judicial test to define investment on the basis of some factors. There has to be a disbursement on the part of the investor. The investment has to be over a period of time, and it has to imply some business risk on the part of the investor, and has to bring some contribution to the state development. These are all requirements, conditions, that are made up by the arbitral tribunal, and then they are repeated over and over. So this is a case of a judicial test that is very successful, used over and over, relied upon by following arbitral tribunals, relied upon by the parties, and relied upon by counsel. Counsel tried to squeeze the argument and the reasoning within the boundaries of this judicial test. Other cases, without going into detail, but just to show you that they are pervasive in international adjudication, how to decide whether a tribunal has jurisdiction in a treaty-based claim, oil platform test from the ICJ, how to decide whether there is a legal dispute and only legal disputes can be adjudicated, Mavromati test, Permanent Court of International Justice, how to decide whether two goods that are traded between countries are so like that the importer can demand the same treatment of domestic production and the WTO commitments, likeness test developed by the appellate body, in this case is over there. So the idea is they are pervasive. You get a sense that these are so recurrent, and the judgment depend on them so much that they sort of start assuming the shape of a source of law, and that is the underlying question. I will give you an example more in particular of the necessity test in the WTO. Now, in the WTO, states enter commitments on trade liberalization. So they agree that they will not block goods at the borders, roughly speaking. There is in the GATT, which is one of the legal texts of the WTO, a provision of general exceptions whereby states are allowed to deviate from WTO commitments only if the action, the measures they adopt are necessary to promote certain public interests. So there is a justification within the WTO whereby states are justified to violate WTO obligations if they do something for the purpose of protecting public morals or human health or something else. The key word here is that these measures must not be simply related to public health or public morals, but have to be necessary. Now, this is all we have in the provision. One word, necessary. I'll show you what the judicial tests look like now. This is the judicial test that has been developed and unfolded to give meaning and to operationalize this word necessary. How can one panel of the WTO or the appellate body decide whether that measure over there is actually necessary and therefore justified? We need a test. And the test, little by little, now looks like this. Don't read this. It's just to show you that it's incredibly articulated and it comes with a lot of sub-tests. And if we would like to summarize it, this is the test that we have in the necessity test. So Italy deviates from its WTO commitments and puts a ban on the imports of cars on grounds of protecting the public morals that are enshrined in keeping car design really Italian, something like that. So obviously the Volkswagen tries to sue Italy, let's say Japan tries to sue Italy before the WTO, and Italy tries to defend that the measure is necessary to protect public morals under the wording of the justification. Now, what the panel has to do is to, this is verbatim, weighing and balancing the importance of the value, public morals, the degree of deviation from WTO commitments, whether it's really trade restrictive or not, and the efficiency of the measure. If it's really trade restrictive but it's not very efficient, come on. This is just phase one. Phase two, make sure that the measure, keeping efficiency equal in terms of trade restrictive, in terms of promotion of the value, is the least trade restrictive. So what we would call proportionality in EU, more or less. So this is the all necessity test in the WTO that comes from the word necessity in Article 20 of the GATT. Now, by now we start seeing what judicial tests are about, and we start seeing that there's something devious about their use that has not simply to do with the fact that argumentation is recurrent and they try to use formula. But by this, I don't want to give the impression that I'm suspicious and I don't like judicial tests and that it's judicial activism. I actually think there are some judicial tests over there that are very much needed and they are not there yet. So for instance, it's still not clear whether in a particular case the tribunal has no jurisdiction or the claim is inadmissible. The result is the same, but we still have no test to distinguish, and sometimes it makes a difference. Or for instance, for those of you familiar with the European Charter of Fundamental Rights, it's still not clear what implementing union law means. So we still have no judicial test reliable enough to know whether the Charter applies or not in some particular cases of state action. So these would be cases where judicial test would help. But what is so normative about judicial tests that we have to investigate the role in the system of sources of international law? So let's see the cases. So first of all, we all know that judicial tests have a legal basis somewhere. Okay, so they don't come from thin air. They come from a norm, a provision, a custom, and they try to elaborate on it. So there is some legal basis somewhere over there. And second, we know that their premise and consist of the expenditure of typical judicial powers of interpretation and application. You know, and so far you could just say, well, what's that all about? You just discovered today that judges interpret the law. Well done. The thing is, there's a third element to judicial tests that is slightly more shady. Because they, by definition, if we look at the formulation, they tend to assume external validity through general wording. Now, this is okay, of course, but it's not necessary. To solve the case at stake, there would be no need to resort to general wording and abstract wording. It would be enough to say, we are judges, we have discretion, and we've been given power to decide whether this measure is necessary, and for this and this reason, it is. That's it. Next time, we start from scratch and we decide whether that other measure is necessary. Instead, there is a tendency to use lock, stock and barrel, it's like formulaire. it's like a very generic reasoning that is used in a repeated way. And why is that the case? Obviously, it is because it aspires to acquire normativity that has to be used in the future as well. Because it wouldn't be indispensable and necessary to create this for just this case. I want this to be used in the future. But also, it's also a way out from a defense from accusations of judicial activism. Because if you shape, if you couch your reasoning in very technical